Professor Saunders, you are the 10th Goodhart Professor to be interviewed for the archive, and the second retrospective scholar, the first being Professor Zines. You held the Goodhart Chair from 2005 to 6, just as this archive was starting up. I'm extremely grateful to you for sparing the time from a very busy schedule participating in the Public Law Conference. Thank you very much. Currently, you are the Laureate Professor Emeritus at Melbourne Law School, and you're also the Director for the Centre for Comparative Constitutional Studies.
No, I'm the founding director of that centre. There is a current director.
Thank you. Just alter that. We obviously don't have much time this afternoon, but I hope we could go through a few topics, starting with your early life, your university education, your professional career, the Goodhart tenure, your research, and then some general views on the constitutional way forward, both for Australia and post-Brexit UK. So if we could start with your early life. You were born in 1944 in Quetta.
I was born in Quetta, which in those days was in India, although it's now in Pakistan, on the northwest frontier. And I was born there because my father was in the Indian Army. My mother was American. She'd gone to India to marry him before the war. And my father was actually fighting in Burma for much of the time around the period when I was born, although I do have some photographs of him actually being there, so I'm not quite sure how that happened. And my sister and I castigate ourselves that we really didn't ask either of our parents about that period of their lives. Because now that I'm older and can understand the challenges that must have presented, to have a small baby in Quetta towards the end of the Second World War, when the war in the Pacific was still raging, with your husband away, seemed to be absolutely remarkable. And my mother got us both out of there and on a ship to the United States when I was 3 months old. So it was the most remarkable story, really.
Well, it's a fascinating trajectory, and particularly when you look at the position on the map. I mean, it looked to me as though it was a sort of a dry, dusty part of the world.
But I think that in the period of British India, it was quite a nice spot in the hills, actually.
Right.
And my impression is that it was a place that you went to get away from the heat of Delhi, for example. I think.
Right.
But I haven't been back. So.
And what made your parents decide then to move to Australia?
Well, the Indian Army came to an end, as you know, with Indian independence. So on any view, my father was going to need to find another career. He, in any event, I think, left before the end because he was involved with the Americans in the occupation of Japan after Hiroshima. And we were all there as a family. I was in Japan when I was 2 with both my parents. And that lasted for a couple of years, and then they just needed to decide where to go and what to do with their lives. And my understanding is that wartime Britain, I think, wasn't particularly attractive to either of them, just because life was so hard, although I had grandparents there. And they tossed up between the United States, Canada and Australia. And came to Australia, and in particular to Melbourne, I think, largely because there were other people from the Indian Army who were there, and they would know some people when they arrived.
So they began their new life in Melbourne, which is then where you obviously...
I grew up, and my sister was born, and really my parents also lived for the rest of their lives.
And you went to the grammar school, the Church of England
Girls' Grammar School.
Do you have any memories of that period?
Yes, of course I do. I mean, everybody remembers their schooling to some degree. And it was a perfectly comfortable period. Rather more interesting, I think, during my sort of schooling was that we used to go backwards and forwards to the United States because my mother thought, possibly wrongly, that she needed to do that to maintain her American citizenship. So we had a sort of slightly cosmopolitan childhood anyway in that respect. And I mention that only because I was interviewed by my grandson, who's now 18, but a couple of years ago when he was a little younger, he decided he would interview me for a school project. And he asked me a question, which was, what was it about my early life that proved influential? And I'd never really thought about that before. But I said to him, and I'm sure it's right, we moved around a lot. My parents didn't come from Australia. We moved around a lot anyway. And so I just grew up knowing that there was a world out there. And I think that has actually been quite influential, unconsciously, in the way in which I've approached life.
And an early start, and to this day, I mean, you are very not averse at all to travel.
No,
and
but very interested in how people live and operate their systems of government elsewhere in the world. Endlessly fascinating subject.
Which began at an early age.
Well, certainly the idea that there was more to the world than downtown Melbourne was just something that was inherent in our household, I guess, throughout my childhood.
While you were at school, were you interested in law at that stage, and perhaps even I noticed one of your interests is archaeology. Did that begin at that period?
Look, I think I was interested in history at school, and my interest in law grew out of that as much as anything else. I did do Latin, classical history, those sorts of subjects at school, as well as other things, obviously. So clearly I was interested in those things, and I did decide at an astonishingly early age that I wanted to do law on the basis of no information about it whatsoever. So I'm lucky it turned out as well as it did.
Yes. Professor Saunders, we come now to your tertiary education.
Mm-hmm.
You did a BA LLB at Melbourne, and you had decided to take law. You did a PhD immediately afterwards, and I wondered whether you had any specialist subjects in your PhD.
The PhD wasn't actually immediately afterwards. It was about 10 years later, at least by the time I finished it. So I graduated from the law school in 1966, and I graduated with my PhD in 1976. And in between that, I had 3 children. Hence the delay, and hence also the fact that I did everything in Melbourne. But yes, the topic of my PhD was intergovernmental relations in Australia, right, which is a sort of an applied aspect of Australian federalism.
And then before you settled into your established career, did you do any postdocs anywhere?
No.
Coming then to your professional career, which according to your CV, tells me that in 1989 you were given a personal chair as Professor of Law at Melbourne, and I wondered if you could say briefly what posts you had in the interim period between doing your PhD and being awarded your chair.
Well, most of my positions were at Melbourne Law School. I did have an earlier position as a tutor at La Trobe Law School, and I don't even recall exactly what happened when, but I think I began as a lecturer, became a senior lecturer, a reader at various stages in that period, and then was given the very considerable honour in those days of a personal chair, that being the sort of chair you didn't need to apply for, which was all very convenient.
And at a comparatively young age as well. And you also were made Laureate Professor, and I wondered if you could recount the circumstances of this appointment, which is a very prestigious position at Melbourne.
It is, and again, so the university has been through various stages in honouring its scholars, and the personal chair was one early stage, but after that period, the university started putting in place a system for promotions to chairs. Before that, there had just been a small fixed number of chairs across the university, for which normally you applied unless you received one of the personal chairs. Once promotion to professor became a more regular career move, there were a lot more professors in the university. And on the basis of that, the university decided it would introduce a higher category, a category of special category of professor, if you like, as an honour to some of its professors, quite small number, I have to say, and also as a mechanism for keeping them, I think was part of the rationale. So the laureate professors, and I think I don't have the figures right, I don't think, but I think at that stage there may have been around 20, something like that, was just a move driven by the evolution of the university itself.
That was in 2007.
Mm-hmm.
And since then, has the number grown?
Well, since then, I think they've gone on to the next phase. They still have laureates, and I don't think that number has grown particularly. But they've introduced yet another category, which is between the laureate and the sort of so-called ordinary professors, so as to be able to recognise the achievements of a wider range of people across the university.
Thank you.
And the price of being a laureate is that I sit on the committee to decide some of these things.
In 2005-06, you were the Goodhart Professor here in Cambridge, and I wonder if you have any outstanding recollections from that period.
It was a wonderful period. I was extremely happy here. I loved the time as the Goodhart greatly, as did my husband, I might say. And it was a very productive time, interacting with colleagues in the faculty here. I taught a subject on comparative public law with David Feldman, which was very entertaining for the students, as you can probably imagine. I was also extremely busy at that time because I was, at that stage, president of the International Association of Constitutional Law. And one of the tasks of the president is to help to organise the next World Congress of the IACL, which is a big sort of world gathering. And the Congress, for my period as president, was in Athens. And there were all sorts of glitches with the organisation of the conference, of the Congress, which in the end was a great success. But I did spend quite a lot of time during my time as a Goodhart professor, rather to my sorrow actually, getting on a plane and going to Athens, and then sort of coming back and traipsing across country again from Heathrow. So that was a very sort of interesting aspect of my time here. But I was also writing a book, or editing a book. Just trying to remember which one it is. I think it was a book on legislative and executive relations in federal systems, which I was co-editing with a colleague, which took quite a lot of my time. I can still see myself sitting in the Goodhart study, beavering away with this book, plus a number of other commitments that I had while I was here.
So it sounds though it was an extremely productive year.
It was a very, very productive year. And our family also joined us for Christmas, so that was a very happy memory as well.
A nice contrast with a typical Melbourne Christmas.
Complete contrast with a typical Melbourne Christmas, but very happy. And I still have contact with a few of the students from that time as well. Two of them in particular were from Melbourne, and I see them on a reasonably frequent basis.
Professor Saunders, that brings us to something of a discussion, or if we could just cover some of your research interests. Mm-hmm. You've written numerous publications dealing with issues of constitutionalism and federal forms of government, many of them comparing different jurisdictions, and I've had try to have a brief look at some of these, but obviously all that I can attempt is a superficial overview. Nevertheless, it struck me that throughout your pieces and your books, there are two sort of thorny issues, if you like, and I wondered whether you could comment on them. The first is the status of the Crown in Australian public affairs, and I wondered how you think this could be resolved or will be resolved.
Well, it depends what you mean by the status of the Crown. Are you referring to the book the article that I wrote there in the Melbourne University Law Review?
I was actually looking at this book,
The
Constitution
book,
of Australia.
Okay, there's several points to be made about the Crown in Australia. On the one hand, there has been, as you know, a Republican movement in Australia, which culminated, at least for the moment, in an unsuccessful referendum towards the end of last century. I expect that issue will at some stage come back on the Australian public agenda again, although it doesn't really look like it's going to happen anytime soon at the moment. My own view is that where the Australians went wrong the last time, apart from the fact that proponents of a republic were trying to achieve it in the face of a government that didn't want it, which is always very difficult, is that they took a far too narrow view of what amounted to being a republic. And they did that deliberately because they thought that would be easier to win, an easier argument to win. Although I'm not sure that was true, because it meant that you had to define a republic as merely breaking your links with the Crown and putting a few arrangements in place to substitute for that, rather than rethinking those parts of the Constitution that are clearly driven by monarchical considerations. For example, leaving it open to the head of state to decide whether and when to dissolve the Parliament, subject to some rather contentious and unexpressed constitutional conventions. And thinking about it more recently, it seemed to me that there would have been advantage, and there would still be advantage, in someone thinking through in a more fundamental way what a republic might actually involve in a country like Australia. So there's that set of issues, and that's an important set of issues. But there's another set of issues which I've also written about in a relatively recent article in the Melbourne University Law Review. And that assumes that we retain the monarchy, but focuses on the use of the terminology of the Crown to personify the state. And one of the things that's happened in Australia, interestingly, I think, and I don't know to what extent it is connected with the formal Republican movement, is that we tend to have reduced our reliance on the concept of the Crown. And in fact, there's High Court doctrine now saying, well, we don't need the concept of the Crown because the Constitution itself gives us a concept of the polity, and that does all the work and more than you needed by a concept of the Crown. And all sorts of jurisprudential consequences follow from that. One of the other things that follows from it, however, and this is why I wrote the article, is that it also casts light on the way in which the different countries in the British Commonwealth have evolved. So despite the very considerable similarities between the underlying constitutional ideas in the United Kingdom, Canada and Australia, for example, and despite the fact that formally we're all monarchies and have the same queen and all the rest of it, our usage of the concept of the Crown is completely different. And so one of my purposes in that article was to show how and why even apparently similar countries diverged in those ways. It's a very interesting issue.
Thank you. The second issue that I discerned is this whole question of the case law, federal statutes and the native title following the Mabo case. And in this regard I had a very interesting conversation with Justice Finn in 2011, and he mentioned how hard it had been for him having to give judgment. He actually physically went to Perth for the case of Bodney and Bonnell in 2008, and he hoped at that point that there would be some federal legislation which would accommodate these situations. Professor Saunders, how do you see this moving forward?
The native title area? Look, my involvement with that has been much more tangential, in fact, although my life touches on it at various points. So in the 1990s, I was involved in a very controversial matter advising the government on whether a particular area in South Australia was sacred to Aboriginal women and should therefore be protected. And so I had some close involvement with Indigenous questions at that stage. I, of course, like any other public lawyer, am familiar with Mabo and the other decisions of the court that surround it. And more recently, I've become reconnected with these questions in connection with a movement to recognise Indigenous Australians in the Constitution, which may, or there again may not, lead to a referendum either next year or the year after. And I've had some indirect involvement in some of the meetings of Indigenous leaders around the country to consider how this issue might most constructively be handled. So that's my involvement in those issues. And Professor Finn's, or Justice Finn's, was of a different kind insofar as he was a judge deciding some of these questions.
Yeah.
I mean, another way of thinking about it is to say it falls into two categories. There's the category that is Australian. That's how I began my academic career, as a person studying Australian constitutional law. And I've remained completely up to date with that, particularly with the federal aspects of it, but not only. But the second aspect of my work is comparative constitutional law, and that also feeds into the Australian material now, although it didn't always, because it enables me to see Australia from different perspectives as well, and I always think that that's a great benefit of comparative law. So I do quite a lot of work also thinking about comparative law, and in fact that's what I'll be speaking on at the Public Law Conference here.
Which leads into the final part of this conversation, which is just some general questions. And I've actually based these upon your considerable experience in comparative federal constitutional work, particularly in common law jurisdictions. And you said in your research paper, Reforming the Australian Federal Democracy, which was published in 2015, that this was the whole question about the sort of interstate relations and then the relations with the actual Commonwealth, and the problems. And you said you didn't think this would necessarily require constitutional change, but that it should not be ruled out. And I wondered what you saw as the ideal way forward for Australia versus in terms of the state-Commonwealth relationship.
Well, look, that paper is not so much a research paper as a diatribe written from the heart. We have a federal system which has become increasingly centralised, and it's become centralised without constitutional change, which means that it's done through informal mechanisms, most of which involve executive action. So to that extent it's become increasingly opaque as well, with lines of accountability extremely muddled, presenting a very complex picture for Australian voters. And it has seemed to me that in itself is a problem for Australian democracy, but that in any event, in a country, particularly the geographic size of Australia, to have vibrant elected levels of government at different levels is highly desirable. Canberra is a very long way from most of the rest of the country. And in many ways, an overburdened level of government. It can't possibly achieve everything it tries to influence. So my argument in that paper, which I also wrote with a colleague, Michael Crommelin, was the real impediment to doing something about this is just to realise that it's a problem. It would be possible enough to rebalance the Federation with a bit of political will and considerable leadership vision. But, and there's no point in saying it all depends on constitutional change, because constitutional change is very difficult to achieve in Australia. On the other hand, if constitutional change were to be on offer, there are all sorts of ways now, in the light of federal experience elsewhere, including, I might say, in this country, that you might learn from and take advantage of to make the Constitution more responsive to these sorts of considerations.
Thank you. The other point, still you're sort of trying to generalise in terms of your considerable and illustrious output, brings me to constitutional issues of post-Brexit UK. And I wondered whether any sort of likely new UK constitutional arrangements with the EU would affect future constitutional relations with Australia.
I don't think so. All the signs are at the moment that if and when the UK actually Brexits, which certainly doesn't look as if it's happening tomorrow, it will seek to strengthen its relations with the old Commonwealth countries, Australia, New Zealand, Canada, wherever. Whether that would happen in a constitutional way or in other ways, including sort of trade and freer movement of peoples, remains to be seen. I was amused as I came through Heathrow yesterday to see a sign saying, citizens from Australia can register for sort of easy access to the UK, or words to that effect. I thought, my God, that's a sign of the times. I was here three months ago, and I don't think I saw that sign then. So it'll be very... look, honestly, I don't think it will make a huge difference in constitutional terms, whatever other social and political arrangements there might be.
Because I suppose that a complicating factor here is the whole question of Scotland, and I wondered whether you thought a solution might be for a formal British Federation arrangement.
Within the UK itself?
Yes.
Well, I gave the Williams lecture here a couple of years ago in which I argued that, there's a sense in which Britain is already a federation. It's not a normal one, and we all know it's complicated by the position of England, but its arrangements are now so obviously have characteristics of autonomy for the devolved areas that it's a federal type model of sorts. Whether you will go further down the path to federalise that, if you think that federation requires a written entrenched constitution, which most places do, is another question, because I think that would be a really big deal here. So it seems to me to be a little more likely at the moment that devolution will, of course, remain in place, and it will deepen, not just in Scotland, but in Northern Ireland and possibly Wales. I see that Wales is suggesting yesterday and this morning that it should have a representative on the United Kingdom Supreme Court. But that those arrangements will be held in place by rather more characteristically British ways of doing things, like constitutional conventions and a little bit of self-denial on the part of the centre. Now, that's an interesting model for the world, but it's not a panacea either. I'm no great expert on how devolution works here, but just reading some of the parliamentary committee debates for the purposes of the Williams lecture, and then I maintain my interest afterwards, it did seem to me that the politicians and the bureaucrats in Westminster and Whitehall didn't really seem to have any great understanding of the concept of devolution or great respect for the autonomous decision-making of the devolved units. And unless they get their act together in that regard, there will be problems. I think that's absolutely right. And those problems may in turn drive you to think about some more formalised arrangement.
Thank you very much. I can only thank you again.
I hope that's been useful to you.
A most interesting account, and I know it's going to be of value to our readers.